Hi everybody, welcome to chapter 11. If you notice, I haven't changed my outfit. I'm trying to do all my last bit of filming for this course in the next probably 2 sessions. I have a couple more chapters to do. This chapter is unique because we're going to talk about law and we're going to talk about legal stuff in schools. I want to just let you know that I have not had to do this chapter. I skip it because when I did this class at Pitt, they cut it. In Oklahoma State, they cut it. Here, it's part of your curriculum, it's part of your objectives that there is a legal aspect of finance, and it's covered in the finance class, not in the law class. So at the other institutions, I normally see this as a finance thing that's a division in a law course. Here, it's a standalone. So this is the first time I've done this chapter, but I normally skip over it, but I'm going to hit the big important topics. Don't worry about reading this chapter as much, but worry about the big ideas that are takeaway messages, and I think that's what's going to help you the most. So, you in school, the law does regulation for organizational purposes, and it does legal liability. The key thing that you have to learn is that as soon as you know that you have control over liability and limited control over organizations, you'll be more functional in a school system. And that really relates to organizational theory. It's just something that you have. If you have control over liability, you won't have much control over the organization and how the organization acts. And just the way it is, and that'll help you be more functional in a school system. So the Constitution makes schools regulated at the state level, but the challenge comes in if Congress says that schools are promoted for the general welfare, meaning it's serving all of society. And it's why we have this issue with federal and state difference in authority, which you need to think about. If the government says we're doing something to promote the general welfare of schools, and the example I always use is the Healthy Schools movement. That got rolled out to all throughout the United States because that was general welfare. Then the federal government can say what happens in schools. So that creates this conflict and this tension between what the federal government says and what the state government says. So that's worth noting. Some of you might be opposed to state power. I like state power. I favor it. I think somebody has to have the power. And I think the state should have it other than the federal government, and I think the state should have it other than the local government. That's just my opinion. But you have to consider the power that the state has, because in our school system, the money comes from the state, the power comes from the state. We're really regulated 50 different ways in the United States. But you have to work with the state level and not against it to understand this. So the state legislature has the right to write any law affecting school that it chooses. And that comes directly from our buddy at the University of Florida. It's the ultimate source of power for regulation of the school system. The state legislature makes a rule, they make funding decisions, and do not forget that. Keep that in mind. That is a big takeaway message and a huge idea in how our school systems work. And you can't lose sight of that when you're looking really at what the school systems are. So most states give power to the boards. Then the board says something's right or wrong, and then the state disapproves it if it's something that goes completely against what the state practice is. School boards really do make the decisions, but they carry out the state functionality. So school boards are powerful, but when people tell me, I'm worried about the school board, I really think that's a district-specific thing. Your power is going to be done to the state. The school board is basically a watchdog to dish out whatever regulations that the state has. But different districts, different power structures, obviously that's the case when you're looking at 67 different districts. So liability, I'm going to talk a little bit about tort law, and I'm going to give you some kind of supplementary information on this that kind of goes outside of the textbook. It doesn't look at specific cases. You don't need to learn cases. You just need to kind of get an overview of this stuff in case this is something that's going to impact you. So, this is the notion from English that the king can do no wrong. So, the government, when we interpreted that from the British and we made it American, we said that the government, the king, can do wrong, but I'm relating this to something that I recently experienced. I'm a huge hockey fan, and I don't have access to hockey. But the government was regulated with the NHL Center Ice case of 2015, and it was a case of sovereign immunity. The NHL would charge you for center ice, and if you watch hockey, you'll kind of understand what I mean. But if the game was shown on TSN or ESPN or the NHL Network, you couldn't get it streamed through your device even if you paid for it. The government stepped in, and people sued the government and said, this is the NHL creating monopoly because those cable networks aren't available anywhere. And this caused us now, with Center Ice, I get to stream all of my games this season, this upcoming season, because I get to watch them on my device. It doesn't matter if they're broadcast on cable or they're blacked out, and it's specific to networks. And that's huge, but it's basically the government stepping in and saying, this is a problem. Somebody sued the government and sued the NHL, and they said that this was something that was regulated incorrectly from the cable company. It's my easiest way to define this because it's something that directly impacted me in the last 6 months or so. So, different athletic events have different liability thresholds than class field trips. Another big idea here. There's different liability thresholds. There's different sort of ways that these are classified. If something goes wrong in an event, the state has to decide whether or not the state or the government should be held liable for it. Big, big, big idea here. That's important. So, nuisance is a condition that injures health, safety, or welfare. I think it's noteworthy that smoking was only considered a nuisance in the last 20 years. Another good example of this, Michigan school district piled snow on a playground, and there was an injury to a child who climbed it. That wasn't a nuisance because it was Michigan and it was snowing like crazy. So these are highly unpredictable, and the authors of our textbook say that determining what a nuisance is and what it isn't is unpredictable, but I think that's worth mentioning. The 11th Amendment exception basically says that the state can't be brought into lawsuits against them, that schools are implicated to the state, basically meaning that schools are an extension of the state. So if the state lets themselves be sued, they can't enter into litigation against the party, and a school is an extension of a state. This is another big idea because that can cause more lawsuits and more issues than you know what to deal with as well. What is a tort? A tort is, the word origin comes from Latin and it means twisted, and a person who commits a tort is called a tortfeasor. So torts are ways to recover money or compensation for injuries. Most of your school system lawsuits or challenges will probably be based in tort law, and they're civil charges, not criminal charges. What you see on Judge Judy and the People's Court are tort court cases, and they're not civil, and they're not criminal. They're civil. Damages are money that comes in. You award damages, and that's your remedy for something going wrong. A ceiling tile fell on a student in one of the districts that I worked at. It was one of those like 2-pound ceiling tiles, and it fell on his head, and the student and his family were awarded damages. You try to make sure that they're compensatory, and it's the actual value of the injuries, but then you have the punitive condition, and that's a big idea here, because this is the stuff that prevents them from ever having that happen again, and it's also a way to say, we're going to make sure that the system is regulated, and it's additional money that's awarded as well. So tort liability is more common in schools than criminal liability. You don't hear about it as much on the news as the criminal instances, but the school could be intentional or negligent, and they could award damages based off of that. So torts are either intentional or unintentional. An intentional tort is when somebody knows and desires the consequences of their act. They know they did something wrong. An unintentional tort lacks the determination of the mind, and that's important to note as well. In schools, the most common issue is corporal punishment and failure to break up fights. That's what we see. if the school does not act appropriately to break up a fight or prevent one from occurring, meaning they see that there's possible signs of a cafeteria brawl occurring, which still do occur, then there's the potential for a lawsuit. But criminal actions can take place as well. So that's an example of an intentional tort in a school system. So negligence is common in schools. It's the most common tort in society, and it's caused for over half of today's lawsuits. The failure to exercise the care that a reasonable person would have exercised is how you can be negligent. So did the school act reasonable in the accommodations and the exceptions that they made for situation A, B, or C? That's the question you would have to ask. So to sue for negligence, you have to have all 4 of these criteria here. This is a big idea. I will have this on the quiz and on the final exam. There has to be a duty of care, a breach of duty, proximate cause of injury, and the actual harm has to be measurable. I'm going to talk about each one of these. So duty of care, was the defendant responsible for care in the first place? So in a school system, well, yeah, the school was responsible for care in the first place. So duty of care never really is a challenge when there's a suit in a school, because the school acts in loco parentis, in absence of the parent. So the school is always going to be responsible for duty of care. But how do you measure that? And was the plaintiff, the school system, responsible for it? That would be the question you would have to ask. So breach of duty. Did they not exercise the degree of care that a reasonable person would exercise in that situation? So then we have this concept in this note of what is reasonable care? What is reasonable person? And then they have to determine if it was done for other students, kind of a utilitarianism type of approach for it. The judge tells a jury what a reasonable person should do. So the judge has a responsibility to explain this. So was the school district negligent, or were they reasonable in their negligent act? So if a teacher wasn't with students for 2 minutes, that might not be seen as negligent, where if a teacher wasn't with a student for 20 or 30 minutes, that would probably be cause for negligence. Just my gut telling me that. So proximate cause. So the definition of proximate cause is something that produces a result and without which the result would not have occurred. So here's my thing for this. Was the injury foreseeable at the time the defendant engaged in the unreasonable conduct? So I have a brick here. If I take this brick and I start bashing it against my head, could I sue and say that this brick caused me injury? Well, no, I couldn't, because I knew that a brick would hurt me. So that's the foreseeability factor. Was there a risk involved? Did the district or did the person take a risk? And if they did, then it's looked upon differently. So actual harm. If there's not an actual harm, then there's no suit. If there's no harm, there's no problems with anybody, then nothing has to be determined as well. So defamation. You can communicate one of the following: so that the person has a disease, professional impropriety, imprisonment for serious crime, or sexual practices of others. That's considered to be defamation of character in United States law. I think it's unique that in Pennsylvania you can defame a principal but not a teacher. There was a case in Keystone Oaks, a district that I actually worked at. Let me go back. District I actually worked in. A principal was sued. Principal sued students and the family over them for defamation of character, and the student won. A principal is considered a public figure in the state of Pennsylvania, and teachers aren't. So that's slightly different. So educational malpractice, it's the relationship between student achievement and quality of instruction. This is the idea of somebody just given a diploma because they didn't want to achieve standards. And when you have a 3rd grade barrier, an 8th grade barrier, or an 11th grade barrier, which most districts do, you can sue for educational malpractice because tests protect a school district that says that a student isn't meeting the objectives. And I know all of us don't like the idea of standardized tests, but there are some positives, and that's one that I would consider and mention. So contracts. Your contract with schools, you have to have the capacity to contract, and the information provided by parties was true. My example for this is a teacher certification. Somebody comes in and says, I am certified as a biology teacher. And they produce a valid contract. The school district accepts them. There's a contract, there's an agreement in place. If the individual doesn't have the proper certification, then that's an issue, and I would say that would be a problem in that practice as well. So school personnel should try to minimize risks and act reasonably, and that justifies the cost risk management in districts and in schools. Prevent before problems occur, that's a big idea. So quick chapters, the last two, you should breeze through them. Hopefully you have a good foundation. I don't have much else to cover, so wanted to give you a little bit of a background on school law. Quick little 15-minute lecture. Hopefully it helped you. Thank you.